everybody. Thank you so much for being here, and it's so wonderful. I have to say, so we're in DC. Usually during the ACS convention, it's 150 degrees outside. It's sweaty and disgusting. You're all really happy to be in here. And the testament to your commitment, but also the incredible interest, interesting program that we have here that on one of the probably most beautiful days in DC, but don't go see how nice it is until we're done here. But you're all in here having lunch with us and preparing for, I think, the final plenary of the day, which is perhaps the most significant one of the entire conference. So thank you again for being with us. I want to make two quick housekeeping announcements. First, for those of you who may not know that the Capitol Steps is performing tonight and we have discounted tickets still available, there are still a few at the desk where the silent auction items are. And you can stop by and look and check those out. The other thing is if you did perhaps win something at the silent auction, you might want to go inquire about that so that you can actually take whatever it is you won home. And there were some very nice items, as you know. So now, I'd like to move to something that's a very important part of our program today. And that is to present the second annual ACS David Carliner Public Interest Award. This award, which includes a $10,000 cash prize, $10,000, say that again. This is for a progressive nonprofit. That's a pretty big prize. We recognize as outstanding mid-career public interest lawyers whose work best exemplifies its namesake's legacy of fearless, uncompromising, and creative advocacy on behalf of marginalized people. The award was established in the memory of one of the great public interest lawyers of the 20th century, David Carliner, who was a true champion of justice, both in his native Washington, D.C., and on the national stage. David Carliner was a tireless, innovative litigator who also played a leading role in building institutions devoted to protecting civil and human rights and combating injustice on a systemic basis. A pioneering immigration lawyer, an ardent foe of Jim Crow laws, and a leading champion of full political rights for the citizens of the District of Columbia, still working on that. He was also the founding chair of the American Civil Liberties Union National Capital Area and the International Human Rights Law Group, which is now Global Rights. ACS is honored to bestow an award bearing his name. The volume and the quality of the applications we received was really very inspiring. The unenviable task of selecting just one winner fell to a distinguished panel of judges: Nan Aaron, Judge William Fletcher, Wade Henderson, Judge Patricia Wald, Deborah Carliner, and Jacob Remus, who discharged their responsibilities admirably. So here to present the ACS David Carliner Award is Sarah Remus, the granddaughter of David Carliner.
Thank you. Like my grandfather, all of the applicants have dedicated this year's award, have dedicated their lives to fearless and creative advocacy. We received particularly strong applications this year. It is with great pleasure that I announce the finalist for the David Carliner Award, Kate Mogilescu of the Legal Aid Society in New York, who fights for the rights of victims of sex trafficking, including helping them vacate prostitution-related criminal convictions. Please stand to be recognized. And the winner of this year's David Carliner Award is Jansen Wu, staff attorney at Gay and Lesbian Advocates and Defenders in Boston. Mr. Wu's battles on behalf of marriage equality and transgender rights perfectly embody my grandfather's passion for civil rights and equality for all. My grandfather was an early advocate for ending restrictions on interracial marriage and for gay rights, and he would have been proud of Mr. Wu's work. Mr. Wu has been a powerful advocate for marriage equality. He led the legislative effort to secure marriage equality in New Hampshire at a time when others believed such a thing was impossible. In his recommendation, Bishop Gene Robinson wrote, "I now have a husband, not just a friend or partner, because of Jansen Wu's efforts in our midst." Mr. Wu has taken the fight into the courts, where he is a lead member of the team challenging the Defense of Marriage Act. He and his team recently achieved an enormous victory when the First Circuit became the first circuit court to rule that DOMA is unconstitutional. It is also appropriate. It is appropriate that Mr. Wu is honored with this award in the name of the person who brought the first interracial marriage case to the Supreme Court in 1956. Mr. Wu has been a leader for transgender rights. While working on the marriage equality bill in New Hampshire, he insisted that his coalition include the struggles of transgender people. He led a litigation effort against Denny's in Maine after the restaurant refused to allow a transgender customer to use the appropriate restroom. Not only did Mr. Wu secure a settlement for his client, but Denny's changed its policies to be welcoming and respectful of all transgender customers. Mr. Wu was a key member of a Maine coalition that protected transgender rights against a right-wing attempt to cut them from an anti-discrimination bill. He is the co-author of a recently published book, Transgender Family Law, A Guide to Effective Advocacy. In 1965, my grandfather won the right of gay employees to work for the federal government, and Mr. Wu's work follows in those footsteps. Please join me in congratulating Jansen Wu.
And now I am honored to present the winners of the Richard D. Cudahy Writing Competition on Regulatory and Administrative Law. This competition honors Judge Cudahy's decades of distinguished service as one of the nation's finest appellate judges. Before joining the bench, Judge Cudahy, a graduate of West Point and Yale Law School, served as an Air Force officer, private attorney, law professor, and chief executive, and member of the Wisconsin Public Service Commission. Since his appointment to the U.S. Court of Appeals for the Seventh Circuit in 1979, Judge Cudahy has secured a national reputation for the depth, rigor, and fair-mindedness of his opinions, academic publications, and speeches. The winning submission in the student category is Administrative Oversight of State Medicaid Payment Policies, Giving Teeth to the Equal Access Provision, by Julia Beinstock, JD candidate at Fordham University School of Law, 2013. And the winning submission in the lawyer category is Adaptable Due Process by Jason Parkin, Associate Research Scholar in Law, Robert M. Cover Clinical Teaching Fellow, and Clinical Lecturer in Law at Yale Law School. So let's give them a big round of applause. So now I'd like to ask Bibi Anderson to come on stage. ACS is proud to stand with the Center for Reproductive Rights to fight for equality and justice for all. I am very pleased to introduce Bibi Anderson, the director of the U.S. Legal Program for the Center for Reproductive Rights. She came to the center in 1998 as a staff attorney and returned to the organization in 2010 as senior counsel. Recently, she briefed and presented successful First Amendment arguments against intrusive mandatory ultrasound requirements in North Carolina and Texas. In both cases, a federal judge viewed the requirements as violations of free speech and granted preliminary injunctions against the law. Bibi graduated with honors from a really wonderful law school, Columbia Law School. So I'm an alum as well. So I am very pleased to be up here with Bibi today. So I will turn the podium over to you.
Thank you, Carolyn. On behalf of the Center for Reproductive Rights, I'm very pleased to be here and joining ACS today at this conference to acknowledge the work of Sandra Fluke, and in her name, the work of law students who've also worked to dedicate themselves to promote the issue of reproductive rights and justice in their law schools and in their communities. Sandra and her colleagues at Georgetown Law, both those affiliated with the Law Students for Reproductive Justice and also with the local ACS chapter, have undertaken remarkable work over the past years. And this was happening before contraceptives were making headlines in this last year. This was happening long before that because they were working to promote the simple principle that contraceptives are an essential preventive health service, and also the idea that even though contraceptives are an essential part of women's health care and essential for women's equality, they're also fundamentally important to all people in our society. Of course, none of us could have predicted the way that Sandra would have come to all of our attention this past year. And, you know, I really do think that we have to be grateful to Representative Darrell Issa and to Rush Limbaugh. Because, really, don't you think? Because if it hadn't been for them, the work of Sandra and so many other law students would not have reached as wide an audience in this country as it did. And it was really due to their clear hostility to women that we were able to learn what courage, integrity, and also grace under pressure really looks like, and how that looks in this next generation of lawyer advocates. So every day at the Center for Reproductive Rights, we fight to make the reproductive rights of women protected as fundamental constitutional and human rights. The governments all must protect, fulfill, and respect. Today, we are thrilled to join with ACS in honoring Sandra Fluke for doing just that and presenting her with the joint ACS Center for Reproductive Rights Student Policy Advocates Award, and to all say to her, thank you and carry on.
Thank you so much. It's quite a thing as a recent law school graduate to be introduced by the likes of Bibi Anderson and Carolyn, who have done so much for reproductive justice in this country. Thank you both for all of your work. And thank you so much to ACS and to CRR for this acknowledgement. It means a lot to me, especially because it is focused explicitly around my work as a student and recognizing that students had a big impact on this political and policy conversation, and also recognizing that it wasn't just me alone who did that, that I worked with so many other students on my campus and at campuses across this country to accomplish this particularly strange type of victory. And I do want to acknowledge that Lucy Panza and Kelly Percival are in the room today, and please give them a hand. These ladies have put in every bit of sweat and tears that I did organizing on this policy, and it's just by absolute luck that I got called a slut instead of them. I'm not attempting to disparage your sexual reputations, ladies. But what I'd like to leave you all with today is just a word of encouragement to make this happen again. Maybe not exactly like this, but to go home to your communities where I know you're already working with students on law school campuses and do more. invigorate them more, help them to find the tools and the cause that are important to them and that they can really make a difference on. Because this policy effort was an absolute boot camp for us of how to be progressive activist lawyers. We organized on campus, we studied legislation, we commented to HHS, we testified, and at this point I think we've got communications going okay. And yes, we even considered litigation, and it was literally us sitting around a table saying, well, in one of my classes, I remember that it's supposed to go like this. Let's try that. So please, find the young, energetic students on the campuses where you are and find ways to work with them and help them to have this kind of boot camp, to prepare them to fight the battles that we all have to fight together. And think about how reproductive justice connects to all of the battles that all of you are already fighting, because that's the thing that's most important to me about the Law Students for Reproductive Justice programming and the reproductive justice framework, is that it connects all of these different areas of oppression and helps us to fight them as one progressive community, not as siloed and isolated efforts. And that, together, is how we're actually ultimately going to defeat the likes of Darrell Issa and Rush Limbaugh. And thank you again very much.
So I would really like to, one more time, thank Sandra and also thank all of our other student leaders who are in the room here today and those who couldn't join us. And I hope we can take 1 second to give a round of applause to all of those ACS student leaders who every day do small and large things to move our movement forward, to make sure that we have a land in which the law is a force for good for all people. So let's thank our student leaders. They know that we are counting on them to make this a better country. So now I'm going to introduce our next plenary, and in particular the moderator, who is well known to this audience. And I think we're also abashed by Pam's remarks about introductions, but I will go forward anyway, introducing a person who almost more than anyone else associated with ACS really needs no introduction, and that is Linda Greenhouse. And so therefore I will give you an introduction. Anyway, for her 30 years at the New York Times, Linda was the Pulitzer Prize-winning reporter who brought the Supreme Court and its decisions alive for America's newspaper readers. Those of us who were alarmed at the concept of a court without Linda's commentary have been delighted consumers of her every other Friday columns in the Times Opinionator section and her frequent contributions to the op-ed page. These recent writings pair her always clear analysis with keen judgments about the history and trajectory of the court and courts more generally. Linda is Senior Research Scholar in Law, the Knight Distinguished Journalist in Residence, and Joseph Goldstein Lecturer in Law at Yale Law School. Can you fit all of those on a business card? That's We are very, very fortunate that she has been a member of the Board of Directors of ACS since 2009, where she plays a key role in charting the organization's course. So please join me in welcoming Linda Greenhouse.
Actually, I thought we would have our whole panel up here at once, so I wasn't actually prepared to make a speech. But as you see, the title of our panel is The Resegregation of America, Race, and the Roberts Court. And Justice Goodwin Luce started us off Thursday night by quoting Dr. Martin Luther King. I would like to start off this final plenary session by quoting from another great American, W.E.B. Du Bois, something he wrote in an essay that was published in 1906. And here's what he said. "We have a way in America of wanting to be rid of problems. It's not so much a desire to reach the best and largest solution as it is to clean the board and start a new game. For instance, most Americans are simply tired and impatient over our social problem, the Negro. They do not want to solve it. They do not want to understand it. They want to simply be done with it and hear the last of it. Of all possible attitudes, this is the most dangerous. W.E.B. Du Bois in 1906. So I'm here to start from the premise that Chief Justice Roberts may be channeling those thoughts. And the kind of title for this plenary in my mind is The Roberts Project, because I think there is a project of Chief Justice Roberts on race, and we're going to unpack that and explore that with some people who've been living this game in litigation and in the academy for many years and have a lot more expertise about it than I do. But so I'll just tee up a couple of the issues that we're going to be discussing in the next hour and 20 minutes or so. So we have a Chief Justice who thinks that the city of Louisville, Kentucky, in the parents involved case in 2007 had no compelling interest in preserving the hard-won gains of integration in its public schools, no compelling interest, okay? We have a Chief Justice who brought us to the very brink in the Northwest Austin Nabudno case in 2009 of declaring unconstitutional Section 5 of the Voting Rights Act, and who's going to have another chance handed to him and his allies on a silver platter in the Shelby County case. That's going to reach the court in the coming term. And we have the grant of cert earlier this term in the Fisher against the University of Texas case. That gives the court a golden opportunity to revisit affirmative action, which Justice Sandra Day O'Connor, writing for the majority in Grutter in 2003, suggested that the court need not get back into for 25 years. So my math has never been all that good, but I don't think we're that close to 25 years. And we have the suggestion by Justice Scalia in his separate opinion in the Ricci New Haven firefighter case in 2009 that the whole notion of disparate impact as a discriminatory harm may itself be unconstitutional, because after all, how do you know whether there is a disparate impact? You have to take some account of race, and to the extent that government taking account of race is presumptively unconstitutional in the mind of some on the Supreme Court, disparate impact as a harm to be remedied is itself unconstitutional. So we've got a lot to talk about and a lot to be concerned about. And I guess now we're going to get rid of this podium because we're not going to have a series of speeches. We're going to have a conversation. Invite our panelists up, and I will introduce them, and we'll start this off. Do with it. Maybe if we get some water, that would be good too. Okay. Okay.
Oh, sorry.
I know you can't see our names because these potted ferns here, but so I will introduce our panel. But I will follow the Palm Carlin rule that Caroline didn't quite follow. So, starting from my left, Jean Nichols, joins us from the University of North Carolina School of Law, which he directs the Center on Poverty, Work, and Opportunity. And he has more experience in higher education than you can shake a stick at. He's been a university president and a law school dean. And so he'll have some thoughts on both affirmative action in higher education and, because of his work on poverty, on the intersection of race and poverty. Reva Siegel, my colleague from Yale, has written widely on race, on the connection between politics and social movements and constitutional law. So we're glad to have her perspective very shortly. Ted Shaw, to my immediate left, former director counsel of the NAACP Legal Defense Fund, now teaches at Columbia. Tom Sines, to my right, is the director of MALDEF Legal Defense Fund. Kurt Levy is the director of the Committee for Justice. He's our visitor from the right. The Committee for Justice deals with judicial nominations, but I'm sure that's not Kurt's only platform for joining us in this conversation. And Elise Body is director of litigation for the NAACP Legal Defense Fund. So I'm going to start with Reva because she's done a detailed examination of where Justice Kennedy is coming from on questions of government policies and race. And of course, it's a truism to think that the resolution of all the cases that I so briefly mentioned will depend on where Anthony Kennedy is coming from. And I think we tend to have a kind of a one-dimensional, almost cartoonish idea of his thoughts on these issues, which are actually not only quite nuanced, but crucially important. So I'd like to ask Reva to unpack Justice Kennedy on race to start us off.
Okay, so the first thing I thought I would do, since we have Fisher on our minds collectively, was simply, with Linda's permission, to read 6 sentences from Justice Kennedy's dissent in the Grutter case. I wouldn't normally start by reading, but there is this very sort of interesting question about where he stands, and the position is complex enough that it felt like it was constructive to try to put some concrete language from him on the table, and then I'll talk for just a little bit about the distinctive features of his perspective. So the sentences I'm reading now are coming just from the opening paragraphs of his dissent in the 2003 case. The separate opinion by Justice Powell in Bakke is based on the principle that a university admissions program may take account of race as one non-predominant factor in a system designed to consider each applicant as an individual, provided the program can meet the test of strict scrutiny by the judiciary. The opinion by Justice Powell, in my view, states the correct rule for resolving this case. The court, however, does not apply strict scrutiny. Having approved the use of race as a factor in the admissions process, the majority proceeds to nullify the essential safeguard Justice Powell insisted upon as the precondition of the approval. In the context of university admissions, the objective of racial diversity can be accepted based on empirical data known to us, but deference is not to be given with respect to the methods by which it is pursued. Preferment by race, when resorted to by the state, can be the most divisive of all policies, containing within it the potential to destroy confidence in the Constitution and in the idea of equality. So, in my just brief couple moments here, I thought I'd start us off by pointing out at least 3 features of those statements. One, on the question of the purposes of race-conscious action, Kennedy is holding that the state may employ race-conscious means to promote diversity in the tradition of Justice Bakke's opinion, Justice Powell's opinion in Bakke. He also, in Parents Involved, refers to equality of opportunity as an important goal for race-conscious state action. But he's raising distinctive concerns here. The state's use of race-conscious means threaten both individualism and threaten what he's calling divisiveness here, social divisiveness. And the third point, that strict scrutiny is a precondition that is going to safeguard the use of race-conscious means so as to minimize those effects, those adverse effects. And in a paper that I wrote last year, I spent some time reading Justice Kennedy and thinking about the ways in which he could be distinguished from both the left and the right on race means. Now here I'm saying left-right on the court, which is its own select group. In any event, and what the bottom line here is that if we have to the right of and here Justice Kennedy is reasoning, as you can see, in the tradition of Justice Powell and also of Justice O'Connor, that to the right of him there are race conservatives who see the key value as individualism and are hostile to the use of race, embrace the anti-classification principle. To the left of him, there are race progressives who are worried about group inequality and embrace the anti-subordination principle and are much more accepting of race-conscious state action when it's designed to break down stratification and promote integration. In the middle, these moderates, the so-called swing voters, I sort of emphasized, are actually not just ambivalent. They're actually saying something that could be intelligibly translated in the following terms, that it's still important for government to engage, that race matters, to use Justice Kennedy's language from the concurring opinion in Parents Involved, that it's still important in this society, given our history, for government to engage in race-conscious action to promote diversity and equality of opportunity. But it threatens not only individualism, but also social divisiveness. Balkanization is the term I use. I sort of emphasize that one can read these three as embracing something like an anti-Balkanization principle, which says that in order to promote, race-conscious action is still important in order to promote social cohesion, but it can't be done in ways that threaten social cohesion. So it's both what, from the left, it looks like they're constantly striking down affirmative action and otherwise, and indeed they do. They're very much believers in the use of strict scrutiny and the judicial overhang. And yet they're also conditionally allowing it to a degree more than their colleagues to the right. And so in this this conditional permission, I'm identifying this concern with social cohesion. And so the last thing I want to say here about this distinctive viewpoint and its relationship to colorblindness is not just different decision rules, but a different focus of attention as to how race matters and where. The issue isn't that government should be oblivious to race or that the courts should stop government from caring about extreme racial stratification or acting to ameliorate it. But, and here is the key point, it seems to me, running from Powell to O'Connor to Justice Kennedy, the issue is not just the horizon of the administrator, the consciousness of the state actor, but the horizon of the citizen. What kind of encounter with government, with the intervention, will the ordinary citizen have? What is the experience of the ordinary citizen of the educational process? That attention leads to, for example, Justice O'Connor and Justice Kennedy saying it still matters in order to preserve social cohesion for government to act to promote integration, and yet at the same time insistent that when government does so, it has to act in universalizing forms so that race is non-predominant, it's not salient in the social form, the appearance of the intervention. I'll stop there.
Well, with that introduction, I'd like to ask our two litigators, or Ted, I guess your former litigator, and Elise currently, armed with that set of insights, you've got to make a case to the court, whether it's the Fisher case or the Shelby County voting rights case, which we'll get into the details of later. So, Elise, how do you argue to Justice Kennedy?
Well, so first let me say that I get the impulse to want to frame these discussions in terms of Justice Kennedy's views. Obviously, we're in that space, and we have to deal with that. But let me just start by, if I could, broadening the frame just a little bit and then return more immediately to your question. John Payton, who was the former Director Counsel for the Legal Defense Fund before he passed earlier this year, liked to say that the health of our democracy depends on all of us understanding and interacting with each other as peers, and that we can't do that if we are racially separate. And so I want to make sure that we properly contextualize this discussion, that this is really about the health of our country, and to Riva's point, the social cohesiveness that we lose when we don't have institutions that are open and accessible to all people. With that, let me make a couple of key points. One is that Justice Kennedy, as I think has been acknowledged, has embraced the importance of diversity, has embraced the importance of avoiding racial isolation. And so I think, at least in terms of the macro picture, he at least has given some acknowledgement to the importance of those values. And I guess the key question that's being teed up is how you get there. And the individualism frame that Riva set out is sort of interesting, because on the one hand, we would suggest profoundly be anti-individualistic to deny colleges the ability to consider race when they can consider everything else. They can consider whether you speak French, whether you play the tuba, where you're from, but not allow them to consider race, which is so often a very important part of who an individual is. That's, of course, not to say that it's always important, but often it is important. So we would submit that that allowing colleges that ability actually serves that value. The other point to take into consideration here is that this is a very narrow consideration of race, that the University of Texas religiously followed the dictates of Grutter, that there was a holistic, flexible, individualized assessment of race. But that said, it has a very meaningful impact. And so I think we would focus on the narrowness of the consideration, but at the same time emphasize the importance in the context of creating an environment at the university that enables it to realize the educational benefits of diversity.
Maybe we should just make sure that people understand what the Fisher case is as the follow-on to Grutter, so people know that Texas, back before Grutter, as a result of the Hopwood case, adopted this 10% plan to have a facially race-neutral way of diversifying the flagship campus at Austin. The top 10% of every high school in the state automatically gets admission to the University of Texas at Austin. Of course, for that plan to work depends on, kind of with a wink and a nod, realizing that the high schools in the state of Texas are themselves de facto segregated. But anyway, this was, working pretty well, as I understand it, but not as well as it might have, because it wasn't producing a critical mass of diverse students in various departments of the university. And so after Grutter, which blessed a holistic form of affirmative action in higher education admissions, the University of Texas tweaked the 10% plan a little bit. They still have the 10% plan for, I think it's 85% of the admittees, and for the other 15%, they do a holistic admissions process, trying to look for ways to diversify across the university, not just en masse, but with some more specificity in terms of interests and departments and so on. And so that's nominally the challenge now. In constitutional terms, it's, well, you've met your compelling interest in diversity with the 10% plan, and so to the extent that you've done this other thing, that fails the narrow tailoring part of strict scrutiny. That's how I understand the argument. And of course, it's presenting to the court an opportunity, because Justice O'Connor is gone, as we know, and Justice Alito has arrived, to get back to basics and redo the whole Grutter settlement, which the court is being asked to do in this case, or not. So, Ted, let me get back to you. I know you've given a lot of thought to the Fisher case and in your former litigating capacity to weigh in here based on Reba's analysis of what we're dealing with.
Well, first let me say how good it is to be here with colleagues and friends, and in one case, friend and adversary. Kurt and I have been on the opposite side of litigation as well as public opinion, but I'm glad that he's here. First, and also I can't, Linda, I can't resist saying, as I turned to Elise when you read that wonderful quote from W.B. Du Bois, which is still very much relevant today, and I said, there aren't, even in 2012, there aren't a lot of white Americans who have read and go around quoting W.B. Du Bois, who is one of the great Americans. But that's a statement, again, about how we continue to be isolated in some ways. I encourage everybody to read Du Bois. I first want to say that for me, Reba, it's very important to say that Justice Kennedy, like Justices O'Connor and Justice Powell, in my view, my humble view, they are not, when it comes to issues of race, moderates. Justice O'Connor's vote on the court is not a vote that we got in race discrimination cases. Think Croson, Shaw versus Reno, Wygant, the other cases that followed Shaw versus Reno, right on up through into the 21st century, except for Grutter. Don't misunderstand me. I am eternally grateful that she went the way she did in Grutter, but I think we have to keep perspective. Justice Powell similarly was very conservative on issues of race. Justice Kennedy is the swing vote, but that doesn't mean he's a moderate vote. And we have seen Justice Kennedy, while he struggles with issues of race, and I'm glad that he struggles with these issues, but we've seen him strike down every race-conscious measure so far that has come to him. And so we have to hope that he does something in Fisher that echoes what he did in Casey, that he adheres to stare decisis, even if he doesn't like Grutter any more now than he did at the time it was decided. Otherwise, to me, our only hope is that now that he is the swing vote, whatever he said in his opinion in Grutter, that he walks over to the precipice and he looks over and says, you know what, this is on me now in terms of being a swing vote, and I don't want to take the country there, even though I'm uncomfortable with race-conscious measures. That's our hope, and it's a slim hope, but it's an important hope. I won't go into detail because I think even in all the time we have allotted for this panel, we don't have enough time to have a full and healthy discussion about these issues. I'm very schizophrenic and have always been about Bakke. We fought to defend Bakke and Grutter, but Bakke on the day that it was decided was a loss to African Americans and people of color, and remains so in very significant ways, and you will see that manifested when Fisher is argued, because there will be no voices on behalf of people of color, students of color in Fisher. That is traceable to Bakke. We could talk about that jurisprudence because that goes right to the heart of the way the court sees these issues, and I think that that's a real deficit in the jurisprudence. Again, one other point, if I may, Linda. You wrote a piece recently that I felt was very, very prescient, as your pieces tend to be. And the piece, well, it's true. The piece was about the court next term in Fisher in particular. And one of the things that you talked about was Chief Justice Roberts and the Roberts Project, as you call it, as you referred to earlier. I think it's important to understand Chief Justice Roberts, with all due respect to him, because we're very polite when we talk about these issues. But I think of him as being the intellectual son of Chief Justice Rehnquist. And I understand Chief Justice Rehnquist's career when it came to issues of race. And he was on a pretty straight line all his career, from the time that he clerked on the Supreme Court when Brown was before the court, right on up through the end of his tenure as Chief Justice on the court. And I don't think that we can find an inch of daylight between Roberts and Rehnquist. And so that's what we're dealing with. So most of us know that this is going to be a hard case for those who are thinking about issues of desegregation. And if we're going to be honest, I think, in talking about anti-balkanization, it's difficult for me to reconcile the consequence of parents involved and say somehow that that's about keeping the country from being divided, and we're concerned about anti-balkanization when what it does is ultimately preserve segregation in public schools.
And I'll turn to the others too, but just to make one contextual comment about parents involved, and also Fisher with respect to what I'm calling the Roberts Project. So the question in parents involved, the constitutionality of voluntarily undertaken modest assignment programs to preserve integration. There was no conflict in the circuits on that question. Parents involved was a combination of cases that came from the Sixth Circuit and the Ninth Circuit, both of which had upheld the plans, and the First Circuit previously had upheld the plans. When Justice O'Connor was on the court in the very last months of her tenure in late 2005, the First Circuit case had come to the court, and the court denied cert. It didn't meet the usual criteria for cert. There was no conflict in the circuits. The minute Justice O'Connor left and Justice Alito came, the two petitions, the Sixth and Ninth Circuit cases came to the court. The court had to have some big internal fight. They took it to conference about 8 times and ultimately granted cert in the absence of a conflict in the circuits. And of course, in the Fisher case from the Fifth Circuit, where the University of Texas plan was upheld by the Fifth Circuit on the grounds of stare decisis, there was no conflict in the circuits because the precedent was pretty clear. So the court, in exercising its ability to create its docket and thereby to tell us what legal issues we're going to have to be consumed with for the coming year, exercised that discretion in that way. But I want to give Kurt a chance to weigh in on this.
Let me just respond to, I guess, a little bit of what those before me said. Reva, I think it was you talked about the court sanctioning the use of race as a non-predominant factor in Grutter in the quote you read from.
No, that was the dissent. I'm sorry. What I was reading was Kennedy's dissent.
I'm sorry, Kennedy.
So it's not the majority.
Right. But that Kennedy, I agree with you. Kennedy, as recently as parents involved, has said that it's okay, for race to be used as a nuanced factor. I think the problem is that it hasn't been since Grutter. I mean, I think I shouldn't say we all hope, but I think conservatives like myself had hoped that we would see the magnitude of preferences, if nothing else, become less, and that's not what some of the analyses indicate. They may be better hidden, and to use Ginsburg's words from Gratz or Grutter, but the magnitude doesn't seem to be less. And now we're told by the University of Texas they want even more. In other words, up through Grutter, it was good enough to use race to achieve campus diversity. Now we're being told that's not enough. Now we need classroom diversity. That's the argument in Grutter. And Linda, you said that there was a promise in Grutter that we won't bother you for another 25 years, but it didn't say do whatever you want for the next 25 years and we won't bother you. I think it laid out here as a compromise that I wasn't very happy with, but a compromise. And again, I don't feel like that compromise has been adhered to. And let's face it, whether we're talking about Justice Kennedy or the people on either side of this debate, it's more than about what University of Texas is doing. I mean, we're all aware, including Justice Kennedy, about what's going on nationwide. And I think if there was a feeling that 10 years or 9 years at this point, through the 25, that racial preferences were dwindling away, I don't think this case would be before the Supreme Court. Elsie, you also talked about race as a flexible factor, and I think maybe it has become more flexible since Grutter, but I don't think it's become any smaller. And I point you to the difference between Grutter and Gratz. In Gratz, we know exactly how much race counted for because it said it in the policy. It was basically the equivalent of one point of GPA, so the difference between an A and a B, let's say. It was more flexible in Grutter, and yet our statistician found that it was slightly bigger in magnitude, that it was about 1.3 standard deviations, whereas a grade point was about 1 standard deviation. So it can be flexible and yet huge. Now, why does it matter if it's huge? Because then it becomes predominant. Then it's not like tuba playing. I don't think you have to worry. Kennedy, I'd be very surprised if Kennedy says you can't consider race at all. I'd even be very surprised if Kennedy says you can't consider race any more than you can consider tuba playing. But I think he probably will say you can't, he will emphasize it can't be the predominant factor. Diversity can't just be a code word for racial diversity. As for Fisher, I think it was Ted who said, but again, I could be wrong here, that the plaintiffs had asked that Grutter be overturned, restructured. Read their brief. I mean, I was looking for that. That's very hard to find. 98% of that brief asks for a win based on narrow tailoring and on the idea that just because there's a compelling interest in campus diversity doesn't mean there's a compelling interest in classroom diversity. I mean, what about a seminar with 8 people? I mean, do we have to guarantee that three of the 8 or 4 of the 8?
Well, of course, Kurt, the Citizens United brief didn't tell the court to overturn BICRA either. But
right, that's not right. I agree. They could go further, but Kennedy has a perfect excuse for not going further in that the plaintiffs only hint at, that maybe one way to resolve this is to clarify Grutter. So again, they can. You're right, but I suspect that at least one of the 5 that you're worried about, Kennedy, won't.
What would you hope to get out of Fisher?
I think I stated it. I'd like to see the court say, we really mean it this time. Even if they were to say exactly what they said, as one of you pointed out, a lot of this is psychological. If the court had said exactly what it said in Grutter, but had said, yes, you can use race as one of many factors, but University of Michigan Law School goes too far, it would have had a very different effect. It's the fact that they upheld the program had a psychological effect of saying, look, this is just, a wink and a nod, keep doing what you're doing. If they just repeat what they said in Grutter, or at least Kennedy repeats it, and they strike it down, I think people will say, you know what the court really means. Race has to be one of many factors in a broad-based consideration of diversity. So again, Kennedy can vote to Ted, you don't have to hope that Kennedy breaks his streak. He may very well vote to strike it down, but essentially not change things from the way they were in Grutter. And I agree that Roberts is very much like Rehnquist, except for one thing, he is a minimalist. And I think he would have a harder time completely overruling Grutter than Rehnquist would have.
Let me turn to Jean as a former college president, and we'll get back to your current incarnation in a different frame. But
I try not to think about that as much as
so, as a as a lawyer and former law school dean and put yourself back in your college president days looking over this landscape and wanting to do what you think is best for your institution. On the other hand, being protective of litigation and so on. How would you be responding to this moment?
Well, it seems to me that in the university community, broadly speaking, looking at this case, looking at the acceptance of Fisher, people are surely worried that it is going to do something more than ratify Grutter, which, of course, there's no reason to take the case in order to simply ratify Grutter. So the fear becomes, or the question becomes, how much how powerful a change will result. Justice Kennedy may well cling to the notion of diversity as a compelling justification. I mean, he could also indicate powerfully that when he says compelling state interest and strict scrutiny, it is much closer to fatal in fact, and therefore a dramatic change in outcome reflected in these cases. It seems to me there's a question of whether the overall framework of the makeup of the decision could be altered. And in the university world, when we look at what's happened at Michigan, what's happened at Berkeley, the fear that the makeup, the diversity of entering classes, particularly with regard to black students, will have to be significantly altered is a potent one. I'm curious with Riva's work, this sort of spelunking of trying to figure out where Justice Kennedy is. I can't tell if he is concerned about balkanization so that he's worried about a majority backlash as he accepts some interest in diversity, or whether it's the opposite. That is, that he's worried, frankly, about a backlash from those who support powerful minority enrollment, and that if he, what he actually seeks to do is to effectively close off affirmative action without declaring that, because that would lead to a backlash and sort of balkanization from the other direction. So these cases are sort of hugely curious to administrators, I think. First of all, for me as an old federal courts person, this case has jurisdictional difficulties and challenges, as almost all the affirmative action cases do, but I assume the court will overlook them as a kind of privilege to challenge privilege, an exemption from Article 3 in order to challenge exemptions. Also for university administrators, especially one who's been involved in these sort of challenges for a long time, I am curious why this is such a potent issue, and yet, particularly for those who have been involved in lawsuits on admissions programs for a long time, things like legacy admissions in the university context, which have, it's just, I mean, there's a lot of great work coming out of the Century Fund here indicating that legacy admissions have a stronger, more powerful impact on the admissions process than is the case with regard to affirmative action. But legacy admissions tend to favor white, wealthy folks, and it seems to me it's a very difficult sort of distinction to draw. We're going to favor legacy and alumni. It's a distinction on the basis of bloodline, which I would think would be one of the most pernicious in terms of American constitutionalism. I know after many years why universities don't challenge legacy admissions, because they think that they're going to get money from it, but I don't understand why those who are committed to a powerful claim of numbers-based or merit-based admissions alone leave this alone year after year when it's so, I mean, at the University of North Carolina, a place, for example, which until relatively recent times didn't allow blacks to be admitted. It's not as if the legacy admissions process is neutral in this sense. So I think the powerful concern, the powerful framework is that we're attempting to close the door on an issue which is still a great challenge in American higher education, and that it will result in a destruction of our powerful and most important claims to equal opportunity.
Let me let Riva weigh in, and I want to.
I got to jump in just very quickly to say, neither of my parents went to college. I hate legacy preferences as much as you do. They're not unconstitutional, but they're absurd in my mind, and the answer is to get rid of them, not counteract them by having racial preferences.
My question is why aren't they unconstitutional? And for one who spends a great career challenging racial classifications, why aren't you challenging these? These are as great a violation of the claims of equality as affirmative action, which has a smaller impact.
For the same reason nobody up here is. It's very hard to come up with a legal theory. But again, I can just tell you from my personal experience that I was even more, when I went to college, I was extremely offended by legacy preferences.
Well, I hope you'll take them up as a legal challenge. It seems to me it's not a very difficult claim to make. The state of North Carolina, the state of Virginia says that we are going to decide who's going to be admitted here in no small part based on your line of birth. Why should an admissions process ever begin with the question, who's your daddy?
Riva, and then Tom.
Okay, so first thing I want to say is right on. So I just wanted to say briefly, make like maybe two distinctions here. First of all, to Ted, I'm describing the courts lineup, which I very much emphasize is not society or the political spectrum, and that it is as narrow a band as it is, and that Justice Kennedy, et cetera, is a moderate on that court, tells us the first thing that connects to other branches of my work, which is one needs to win elections. That is, this, I mean, this spectrum is not the full spectrum, and we need to do something about that. Okay, so that's the first point. Secondly, given that this is the bench that we're facing now, it then becomes important to be attuned to distinctions amongst those who are seated there if these programs are to survive at all. This is what led me in work on in substantive due process. I have focused on Kennedy, trying to understand where he stands on that range of issues, and also on race questions I've done same. And it's important to see distinctions, I'll just call them for now, distinctions among conservatives or distinctions on the right. And on that's what I'm trying to draw into view here. And the reason I'm trying to draw it into view, and now I go to my second point, this is to Kurt, I don't consider Chief Justice Roberts a minimalist. He's not a minimalist. And if you read carefully what it is that he committed to in Parents Involved, he would eliminate this and a lot more in a heartbeat. So that goes back to my first point about winning elections. And now finally, Jean, to you, I want to say simply that the reason that we're in this conversation focused on affirmative action programs and not on legacies is because this court construes the Equal Protection Clause with the paradigmatic case of applying strict scrutiny to civil rights initiatives. That's what it's doing. It is not scrutinizing other policies that have a disparate impact on racial minorities. That once was our Equal Protection Clause. That is no longer our Equal Protection Clause. This court has isolated this set of initiatives for its strict scrutiny.
Tom.
Thank you, Linda. Look, I'm glad to get an opportunity to talk about Fisher because, frankly, Fisher comes out of the state of Texas. The state of Texas doesn't look anything like the Supreme Court, doesn't look anything like this panel, doesn't look anything like this room. The state of Texas is 38% Latino in population. An even higher proportion of the students in Texas schools who will eventually be applying to the University of Texas and other universities are Latino. Now, I raise that by way of pointing out how troubling it is for those of us in the Latino community who have litigated and are still litigating these issues. This case comes to the Supreme Court out of Texas. When you are 38% of the population and even higher of the pool of students, a diversity-based rationale sounding in critical mass, which is the test that we now face in Fisher as a result of Grutter, is very troubling. Because it suggests that even if you are a very high proportion of the population, a high proportion of the pool of potential students, that the Constitution would say, far short of that proportion, that you can no longer consider race or racial disadvantage. I would say to Kurt, part of the reason, if you are correct in asserting the consideration of race is not diminished, is because in Texas and throughout the country, racial inequality, social inequality have not diminished. And in Texas, we are talking about a kindergarten through 12th grade public school system that has repeatedly been subject to challenge because of those inequalities. And as a result of a long ago Supreme Court decision in San Antonio School District versus Rodriguez, it is not a question that the federal courts with life tenure are considering. It's a question that is repeatedly, more often than not by MALDEF, litigated in the state courts, where judges are subject to political influences, where the legislature gets involved in almost a negotiation between the courts and the lawmakers about how to address those issues of inequality. And it is absolutely clear, when one looks at history, that those continuing inequalities are a result of racial discrimination. Even the way Texas school districts are drawn, the fact that there are multiple school districts in each urban environment, is a result of racial discrimination. So the problem with the case coming from Texas is that it will be considered, as too often these cases and more all cases are considered by the justices, in an entirely decontextualized fashion. The diversity rationale itself decontextualizes the issues. Because while the Supreme Court talks about diversity, folks are actually making these decisions know that the reason we consider race in affirmative action is because of the effects of discrimination, past and continuing, because of the biases that still inhere in the criteria that are used to evaluate who has the greatest potential. So the decision makers know that if you really want the students with the greatest potential, you have to consider those biases and discrimination, and the way to do that is by taking account of race. But the Supreme Court, in a completely decontextualized fashion, has us only consider diversity as the relevant test. And I want to make a broader point. I think that this decontextualized consideration that has been so much a character of the consideration of affirmative action since Bakke. By the way, Bakke challenged an affirmative action program that benefited more Latinos than any other group. Not a coincidence that Proposition 209, the legislative effort against affirmative action, started in California. In fact, the champion of 209 once indicated in an interview that the reason he put it forward was his concern about the growth of the Latino population in California. So I take a lot of these issues about the backlash against affirmative action very personally with respect to my community, the community that I represent. But in terms of decontextualization, it occurs in other cases as well. And I just want to mention Arizona versus United States. Probably the most racialized case on the docket of the Supreme Court this year. But it sounds in claims around supremacy and preemption, appropriately. Those are the right claims to bring. But because of that, it will be considered, indeed the oral argument made that crystal clear, in a totally decontextualized fashion that will ignore that Arizona's SB 1070 has its genesis at least as much in the growth of the Latino population in Arizona to reach a quarter of the population, at least as much in Governor Brewer's needing a wedge issue directly related to the growth of the Latino population, as it had to do with any sort of concern about undocumented immigration. But the court will take up that case and decide that case in a totally decontextualized fashion with respect to those issues. This is a very troubling development. Now, colorblindness, however faulty and discredited it may be, is ostensibly a theory about legislating and policy making. It is not a theory about judicial decision making. But that is how it is evolving. It's evolving into a doctrine that says to some Supreme Court justices that colorblindness isn't the criterion by which you evaluate legislation. It's how you go about making your decisions. You ignore any context related to race whatsoever, no matter how appropriate or relevant it may be, and that's the one element of context that you are to ignore. And the development of colorblindness, the evolution or devolution from ostensibly a theory about legislation and policy making into a theory of judicial decision making ought to be tremendously troubling to every one of us.
That's great.
Let me say amen to what Tom just said, and it goes hand in hand exactly. We're saying the same thing in large part when I talked about Bakke and why Bakke was a loss, and Bakke being ahistorical and decontextualized. Absolutely, and there's so much that in what he said that's rich. But I want to come back even to say that I understand what your writing is. I still think it is important. I mean, I don't think we have much of a disagreement at all, but I think it's important for us to keep pointing out how radically conservative this court is, and the fact that this court, when we talk about moderates being in the center of the court, that's not where that's not who the people at the center of this court are. They are very conservative, but we do have to slice and dice them for purposes of making arguments to them on issues that are presented in the cases involving race. Very quickly, in response to Kurt, by the way, you misattributed something to me, but that's all right because I would have said it anyway. We could have a very viable theory with respect to attacking legacy if we had a healthy Title VI with a private right of action. But what I encourage you to do, even if you think there's not a legal theory, certainly you spend a lot of time in the court of public opinion. And that's an issue that you could spend a lot of time and energy on in the court of public opinion, and it might be one in which we can reach across ideology and agree upon. And
Agreed.
Finally, I want to say one other thing about Fisher very quickly. We haven't done justice to Fisher, but at the moment that the Texas legislature adopted the 10% plan, and the 10% plan was deemed to be a colorblind post-Hopwood approach. In reality, everybody knows why it works. It's don't ask, don't tell as applied to issues of race. But at the moment that was applied, very quickly there developed instantly a constituency throughout the state of Texas, a political constituency in support of the 10% plan, quite aside from race. White folks in rural school districts had never sent anybody to the University of Texas. Here we're talking about issues of class and privilege, who support the plan because all of a sudden 10% of the graduates of those high schools were going to get into UT Austin. UT Austin hates the 10% plan for reasons that should be obvious to everybody in the room, but this is not going to be undone because there's not a political constituency for it. That's very important when we talk about this case, and the overlay of Grutter diversity was, as I think Linda pointed out, to get to the critical mass in certain specific kinds of programs. If we have to live with the things about Bakke that I don't like, that we haven't explored in great detail, and in some it's that the only viable justification for programs that are going to open up opportunities to people of color in a conscious way are diversity-based programs as opposed to remedial programs, part of what Tom just talked about also. But if we have to live with that reality, then the diversity justification would in fact allow broad, aggressive, healthy efforts to achieve diversity in all corners of the university, if we're being honest about diversity. Folks on the right don't like that because they don't like diversity, period, as a compelling state interest. But that's my view on it. And I think what the court has done is backed itself into a corner.
Can I just jump in for a
Please,
second?
and also if you want to if you want to help me pivot to the Voting Rights Act situation, I'd appreciate that too.
Sure.
And Elise, you're too kind to say this, but Kurt, you haven't gotten to know Elise. You miscalled her name. It's Elise. Yeah.
Thank you, Ted.
All I know is it's big shoes to fill.
So I confess to having this sort of split conversation going on in my head, which is depression, optimism, depression, optimism. And, you know, look, I think it's worth reminding folks that Grutter was a tremendous surprise, right, for the reasons that Ted alluded to, right? Justice O'Connor was not with us on, I think, any of the race cases that came before her. And we were really not at all prepared for the opinion that she eventually issued, which was this ringing endorsement of diversity. And arguably an opinion, maybe not so arguably, that went beyond Justice Powell's opinion in Bakke. And so let's not be so pessimistic as to rule out the possibility that Justice Kennedy might find his way to upholding this plan, to upholding Grutter. You know, as Ted says, if he looks over the precipice and he sees what's really confronting the court, you know, that he might blink and rule in a way that might surprise some of us. It only takes 4 votes to grant cert. We don't know whether Justice Kennedy voted to grant cert. I agree with everything that's been said with respect to Fisher. There was no reason for the court to take Fisher. There was no split among the circuits. But again, we don't know if Justice Kennedy was one of the folks one of the justices who voted to grant cert. And I think that Ted's point with respect to the Casey decision, right, which was the decision that upheld at least the shell of Roe versus Wade, where Justice Kennedy surprised his colleagues and on stare decisis grounds voted to uphold Roe, at least in theory. So those are some important points that I just want to make sure that we get out there. I have to also say that I want to push back on this notion. Well, actually, let me say one other thing. I think it's incredibly important, and I hear Tom and I hear Ted on the need to make sure that we frame the conversation, if you'll pardon the pun, in a more holistic way. And that is to set the table and really to understand that we are living in a society of profound racial inequality. And Kurt, with all due respect, I mean, sometimes I sort of feel like in the Matrix, where you have these, men running around in sunglasses trying to promote this sort of notion of this alternate reality. I mean, the world that you describe, I just don't understand the alternate reality that you're describing. Race still very much matters. You can open up the newspaper and see how much race matters. Trayvon Martin, the voter purges in Florida, the voter suppression, the efforts to suppress minority votes going on in Texas and South Carolina. So, this notion that we live in this colorblind society is just completely wrong. And, colleges and universities occupy the educational space in that context, right? They have to live in the real world. And Grutter recognized that. The court recognized the importance of enabling universities to take into account race, so that students who in the K-12 context, as Tom described, so often attend elementary and secondary schools completely isolated from one another. Universities are the only context in which students have the opportunity to learn to meaningfully interact with one another. So with that, I'm happy.
Can I respond very briefly to?
Yes, you're right.
I don't remember saying that that we lived in a colorblind society. I don't think we do. But I do agree with Justice Roberts that the only way to achieve colorblindness is to head in that direction. And again, I think the 25 years was fine if we really head in that direction. And in some sense, this whole debate, just to tie a few things together, isn't really about race. It's about preferences. People like their preferences. The people who get legacy preferences for their kids like them. The people who get preferences through the top 10% plan like them. Various racial groups like them. But to me, that just is all the more evidence that it's cynical. And Tom, I didn't get a chance to ask you this, but you know that there's even favorites played among racial groups. That typically it's Mexicans and Puerto Ricans, or at least Mexican Americans and Puerto Rican Americans that get the preferences, not so much other groups. That was explicitly true in Grutter. I think all Mexicans got it, but only mainland Puerto Ricans. So and that hard to explain that other than the political strength of groups. Now Arab Americans are becoming more politically powerful, and we see the Commerce Department considering them giving preferences. And to me, that's not the answer, to just keep adding on more preferences. The answer is to try to work towards a merit-based society. And maybe we can't get there today, but I was kind of hoping, 15 years from now, we'd be closer.
Let me respond to you. I think the issue is, what do you define as a preference? Since you're raising both legacy preferences and racial preferences, we're talking about racial and non-racial preferences. I would argue to you that the existing criteria that are used, standardized tests, grade point averages, coursework that was taken in high school, are a form of preference.
Then get rid of them.
Good. Let's go out hand in hand and get rid of that preference. But what are we going to be left with? We're left with no decision-making mechanisms whatsoever. So what we've got to do, I agree with you, is strive to a decision-making mechanism that demonstrates time and time again that it successfully chooses students with the greatest potential and that does not have bias within it.
And I agree with
But
you.
we ought to know if we have a preference system, a system of selection right now that results in the kinds of racial disparities, that'll be prima facie proof that those are not the most efficient and effective mechanisms of making decisions.
If the SAT and the GPA is a bad measure, then it's a bad measure for white kids too. Get rid of things that are bad measures.
If you and me and Ted would make it our goal to go out and reinvigorate Title VI and the disparate impact standard and give it a private right of action, we could challenge the SAT. We could challenge legacy preferences.
Okay.
So I will join with you in making that our #1 goal.
Fine. I would much prefer diversity through getting rid of criteria that have a disparate impact than diversity through preferences.
And
I'm glad you're on
agree.
record.
Let's make that our top priority. Let's
Okay,
get rid of those criteria with the disparate impacts.
I'm not tied to.
But while we're waiting for
standardized
that,
tests
while
at
we're
all.
waiting for that happy day, we have to talk about voting rights. So there is this case, Shelby County, which came down from the DC Circuit last month, a divided opinion 2-1, upheld Section 5 of the Voting Rights Act, the pre-clearance section, against the claim that because of the post-racial society to which we're evidently all hurtling, the Section 5 remedy, which is the mandatory pre-clearance for the covered jurisdictions for any voting change, was no longer a congruent and proportional remedy. So that's the claim that was rejected by this narrow margin on the DC Circuit. A cert petition will soon be on its way. And speaking of Robert's minimalism, what struck me as just about the most interesting thing in the 100 pages of opinions in Shelby County was a dissenting opinion by Judge Stephen Williams, who said, we don't need to strike down Section 5, which may well be unconstitutional, but we don't have to go there. All we have to strike down is Section 4 of Section 5, and Section 4 is the formula for what's a covered jurisdiction, which is, as you know, a number of states in the South and some other parts of other states. Those jurisdictions are no worse than others now, and the time has overtaken those distinctions, and so we should just remand and tell Congress to change the formula. Now, I'm here to tell you that if the court does that, and it may be a very appealing outcome for the court, it will look very minimalist, but Congress won't do anything, and we'll have Section 5 functionally non-existent. That's my view. But I'd like to give people
Well,
a chance to weigh.
that's consistent in my view with the way the court is more likely to operate. It's what the court did to Brown with parents involved. The court already has gone out of the business of mandatory desegregation. Those days are over, and all you had left was voluntary desegregation measures. And those are struck down as unconstitutional. And that leaves, as I've said many times, Brown hallowed but hollow. And I think that's more likely the way the court is going to approach the Voting Rights Act. I don't think it'll overturn it and say it's unconstitutional, but it's going to gut it. One more thing on the table that's related to all of this that I think is very important. Kurt, you and I, you know, we have a very fundamental disagreement. My goal is not colorblindness. I've given up on that because you all own that. You know, my goal is, I mean, the question for me isn't whether we see race. The question is, what is the significance? You know, the goal to me is to, in spite of race, treat people with dignity, human dignity, and to open up opportunities to people. And this equation of measures that are aimed at doing that with invidious discrimination, you know, that's a false equation. There's no symmetry between those two things, but that symmetry is part of the core of the court's jurisprudence. And it will be part of what the court will rely upon if, in fact, it does gut the Voting Rights Act, and it's what the court seems to rely upon when it approaches so-called reverse discrimination cases in the context of diversity.
But part of dignity to me is being treated as an individual. And that's one reason that I rebel at the idea of group rights and prefer colorblind. But by colorblind, and I'm not sure exactly, I know we disagree to some degree. I may have forgotten exactly what your position is, but I don't think I'm saying that I really believe that we're never going to see race. But, you know, for better or worse, mostly worse, in most parts of the world, people hate each other for other reasons like religion. You know, in this country, yes, race has sort of been the predominant factor, but I'm kind of hoping that before I die, that we'll see race be something we recognize, but it won't be the predominant factor by which we measure whether people are getting, whether a campus has true diversity or...
Let me make this point, and then I will cease.
Are you prepared
Let me make
to
this point, and I will cease. Because you put your finger right on it. What we are doing when we pursue diversity in admissions, colleges and universities, and in other contexts, is not based upon hatred. You know, quite the opposite. Mm-hmm. Hatred was the basis for invidious discrimination. We're talking about two different intents. And the court, which seems to have no problem requiring intent with respect to the 14th Amendment, requires us to get into the minds of actors, somehow becomes befuddled once it's in the minds of actors and cannot make that distinction. That's a deeply dishonest and problematic jurisprudence.
I would never deny that there is, I feel there's a difference in intent. But as I think I've explained to you on numerous occasions, not everyone feels that way. At least 2 of the 3 plaintiffs in Michigan really felt like they were being picked on. And that's what I mean by...
They were picked,
yeah,
those plaintiffs.
Well, they came forward, but I don't want to get into that. But the bottom line is that they didn't feel that because white people in general were doing fine, that it was okay, that they felt like they were being devalued. That's honestly how 2 of the 3 felt. So it's not, again, I've never said that the 2 are exactly equal, but I've also tried to get across the point that it's not as if, you know, there's no cost to discriminating against white people.
Could I add that Kurt makes the point that he would like it very much, and I believe that to be true, that if in 20 years or 30 years or 40 years we were past this problem. One of the great challenges that it looks like we face right now, if we move beyond these very large challenges like affirmative action and the Voting Rights Act and disparate impact, and whether that can be rendered unconstitutional, is to the largest of these questions, that is this great problem of American history, frankly the greatest sin or transgression against American democracy from the first day of our history till now, that is race, whether this is over. I mean, that's a huge part of what's happening across the board on these cases. And in none of these areas is the court acting, or the five, or the four, are they acting with clear textual and historical mandate here? So this sort of powerful question is, will these five decide that this largest question that we have ever faced is finished? Will they do that in some sort of move of constitutional judgment? And will they decide it for all the rest of us and remove the possibility of integrative or remedial race-based decisions from us all? That is, this raises huge and remarkable questions of legitimacy, for one thing, and the sort of power of the dilemma that we face, or the barriers that we will face as a result of it, astounds. So this is the largest of all questions, and ask yourself what you think about these 4 or 5 having the final word.
Can I just, because I'm sorry, my head almost popped off, Kurt, when you said, you know, that the plaintiffs in the Michigan cases felt as though they'd been picked on. I mean, the frame that you're using is a frame of victimization and entitlement by white plaintiffs who are challenging policies that, but for the existence of some of these policies, we would see the resegregation of many colleges and universities, selective colleges and universities. University of Texas is a little bit different because of the 10% plan. But I really think that we have to push back against that we're not, that this is a contextual experience, that we're talking about a broader social vision to create, to Reva's point, more social cohesion by creating inclusive institutions of higher education. So that's just.
And I want to.
I was just describing their emotions,
cut
not
off
making
before.
a framework.
I just want to say, and to amplify this, but for the court's strict scrutiny jurisprudence, they wouldn't think to challenge their exclusion on racialized terms. That is, the court's very framework encourages people who don't get, there is class salience to our admissions criteria. There are terrible intergenerational problems of exclusion going on here. We could have an equality jurisprudence that was comprehending both exclusion on class as well as race grounds. There's no reason we couldn't be more comprehensive about it. It's a question contingent, historically contingent understanding of equal protection that we're not. But strict scrutiny encourages someone who doesn't get into a school, the only way they get voice is by talking about it as a racialized exclusion. First point. Second point, and this goes back to my observation that the entire framework is selective in what it focuses on as a problem of equality. What about the use of race in suspect apprehension? What about, Trayvon's experience, getting picked on, as it were? There are deep, deep issues about what we see as race-based state action. If those who are opposed to race-conscious state action want to eliminate wholly the use of race from even suspect, then we can talk about an evenly applied principle. We're not in that zone, to say the least.
And that is why, to the point about equal protection jurisprudence. So that is, this is Texas in the Fisher context, right? The institution of Sweat versus Painter, which put Heman Sweat, outside the classroom, right? Wouldn't even allow him to sit inside the classroom to learn with his white peers. And the question was whether that was unconstitutional, and the court struck that down some time ago. But to equate, Heman Sweat's situation with this, with Abigail Fisher, where the university is creating, this inclusive environment, there's absolutely no suggestion that whites are underrepresented at the University of Texas. And also, I think it bears mentioning that that race can be relevant for whites too. So for a white student, for example, who attends a predominantly Latino or Black institution, right? That might be a relevant part of that person's experience, which should be taken into account in the admissions context.
Tom, so Texas being kind of ground zero for voting rights as well as for the Fisher case, I'm really interested in your perspective on this, because the Latino community has a lot at stake in the voting rights area, obviously.
Absolutely, thank you. I think that if the court decides to, either way, Section 4 or Section 5 really eviscerate the pre-clearance mechanism. It's something that we all ought to lament, not just as a matter of jurisprudence, but as a matter of effective policymaking and effective implementation of civil rights policies. Indeed, I think one could argue that the reason we have not made the kind of progress that we should have made in other areas, including educational equity, is because we don't have similar mechanisms to ensure review, monitoring of what's going on in jurisdictions around the country. I would argue that part of the reason that the education equity has not gotten as far as it should have is not only because the Supreme Court shut down the federal court avenue in Rodriguez, it's also because we don't have aggressive enough mechanisms to ensure nationwide adherence to education equity standards. If we had a Section 5 kind of mechanism in No Child Left Behind or Elementary and Secondary Education Act about reducing the so-called achievement gap, I guarantee you we would have had much more success in shrinking the achievement gap. The simple fact is when you leave courts as the only avenue, in the case of education, state courts, as the only avenue of fixing a broken system when it comes to inequity, that is not going to succeed. And indeed, that ought to tell us, as often as that mechanism, as difficult as it is, has had to be used across the country to try to address these issues, that ought to tell us that our existing mechanisms of monitoring and ensuring implementation of nationwide standards about education equity is broken and we need to arrive at another one. And a system like Section 5 that requires monitoring and review at the federal level is something we should be considering and implementing in other areas rather than abandoning in the arena of voting.
We're down to our very final minutes, for which I apologize, and also apologize for not having reminded people who want the CLE credit that's available for this to sign in and sign out over there. So I'll just ask one of the few audience questions here, and maybe somebody here knows the answer, but it's a good question. Where are things at the local level in light of parents involved? What's happened to the things that Justice Kennedy said are permissible? And what, if you recall what Justice Kennedy said, things like location of new schools, and in other words, a basket of race-neutral policies where the government is not in the business of actually identifying individuals by race. Does anyone know?
He also allowed for explicit consideration of race. He had said it had to be more nuanced and individualized.
So do we have an impact from parents involved that anybody can weigh in on? No?
My sense is that school districts have taken a hard look at parents involved to determine the contours of what they can permissibly do, and taken a hard look at Kennedy's opinion, decisions about location, drawing attendance zones in ways that don't focus on the individual race of students, but may look at the racial identifiability of neighborhoods. But it's a pretty slender read, frankly, on which to hang integration. But I think, what's good about that is that school districts do recognize and appreciate the value of diversity and inclusion and opportunity. And school districts like Louisville in Jefferson County, Kentucky, that had previously discriminated on the basis of race actually now seek to promote more inclusive, racially inclusive student bodies. And so we've seen actually how previously bad actors can turn a corner. And I think, if there's any bright horizon out of the Louisville decision, is precisely that Louisville's looking for a way to continue to promote inclusion within the contours, the very narrow contours of Justice Kennedy's opinion.
Well, we sort of end where we began with Anthony Kennedy, but I thank the panel, and Caroline's going to